August.
Welcome back to the Law News Network, everybody. This is Jesse Weber. We are cutting out of that prior testimony, the prior coverage of the opening statements in the Adam Matos case because we want to discuss it a little bit. And here to help me talk a little bit more about it is LawNewz's trial analyst, Deborah Blum. Deborah, thanks for joining us here today.
I'm so happy to be here with you.
Oh, I don't blame you. Okay, next question. I do have a question about this case. Okay, I have a lot of questions about this case. First question, I keep asking this from every one of the guests that we have. I don't understand not only why the defense has chosen to has elected not to provide an opening statement. Okay, they might want to reserve it, but even so, they haven't been cross-examining a lot of these witnesses in depth, and they're really reserving their case in a way where if I'm in the jury right now, it's just evidence against evidence against evidence against Mr. Matos. What do you think about what the defense's strategy is right here?
You know, if I was a defense attorney here, first of all, it would be very difficult to defend this case. There are a lot of factors that are pointing towards the prosecution being able to win this case. I don't understand why the defense didn't give an opening. The number one rule that you learned during your trial preparation class at legal aid is you give an opening. You know, you have, even though a defendant has no obligation unless they raise an affirmative defense, you give an opening, even if it's called a non-opening opening, which just means you discuss what reasonable doubt is, that it's the highest burden. So I'm not sure why the defense didn't do that here. You know, sometimes I think that the jurors get bored, so perhaps their thought is, let's just give the case to the jury and then we're going to present our alternate defense when we have our chance. But then they're also not, meaning when we have our case and we're going to call witnesses, most likely they'll pursue that Nicholas Leonard's ex-girlfriend was obsessed with him and perhaps she hired a hitman to kill him and this family. But I'm not sure why they're not trying to weave that in on the prosecution's direct case, and when they get to cross-examine, it's really baffling.
Maybe it's because, and correct me if I'm wrong, what we've seen in other cases, when you throw in that additional suspect, okay, they're already involved in that story somehow. Okay, so we saw that kind of in the Aaron Hernandez case. When you point the finger at somebody else, you talk about Alexander Bradley at the time, he was already part of that conversation in the prosecution's case. Here, if maybe, correct me if I'm wrong, if the defense goes, okay, we're going to introduce this new character to you at the beginning, then the prosecution goes through their entire case without ever mentioning this woman because she's not connected to this, bring it up at the last point, and then the defense brings it up, it might not tie in. However, if you can say at the beginning, okay, prosecution, they put on their case, we argued it, now let's tell you what really happened. Is that something that they might be doing?
I've never seen that before, but perhaps. I don't know what the ruling was about their opening. I don't know if the judge is going to allow them to do it when the defense does their direct case. So it's possible that they don't want to weave that in the prosecution's direct, because then the prosecution would have the chance to be the one that the first shot at it and, you know, hits it out of the ballpark and shows that it's not even possible.
Yeah.
So perhaps they're doing that, but the prosecution is going to have the opportunity to attack it if the defense does it on their direct case. So
yeah.
I'm really not sure what the strategy here is. You know, sometimes you don't want to bore the jurors because there's so much testimony, especially in a gruesome four-person murder case. There's so many details that the jury is going to hear, but you would think that the defense wants to poke some holes.
Maybe we're going to see more of those holes, maybe like where they really attack in cross-examination the eyewitnesses, maybe the evidence that was collected more. Maybe that's really where they're going to see it, because right now we saw some testimony from family members. We saw the testimony of a forensic investigator who's collecting items, but maybe it wasn't the opportunity to attack yet. Maybe things will change. We are going to have live coverage here at 9:30 where we'll see more of this. I want to talk about some of the facts now that are really, or the evidence that's being put forth by the prosecution that seems to go against Mr. Matos. Do you think the idea that he was not forthcoming about the last time he was at the house is going to be his downfall? I mean, he said the last time he was at that house was the morning of August 28th. When we're going to see from testimony and evidence, that he was living in that house for a few days. What, you think that's going to be his downfall? Because how do you explain that?
I mean, I think there are so many things that could be his downfall here. He was ordering pizza at the house where he had probably decomposing bodies, and he wouldn't let people in. He was selling off the family's thoroughbred dogs for very low prices, but he wouldn't let anybody into the home. I think that's a problem. You know, people lie to the police. That doesn't always mean that they're guilty of the charged crimes. People get very nervous when they're being interrogated by the police, so I don't know if that's actually the downfall. I think that the fact that 911 was called earlier in the day, where you heard her, the girlfriend or his ex-girlfriend, the mother of his child, screaming, being very nervous and fearful, and you have other witnesses that are going to say that she was fearful for her life as a result of him, as a result of Matos. I think all of those things are extremely damaging, and this is a cumulative effect where you could add everything up.
So it doesn't. The defense is not going to have an argument here, because here's what I'm curious about. The guy is ordering pizza to a house. If you take what the prosecution says, the guy's ordering a pizza to the house while there's decomposed bodies. He's going over to his neighbor's house, Ryan McCann. He's hanging out with them. He's having beers. He's going out with him. How does someone who just committed a quadruple homicide in such a brutal fashion able to act as if nothing's wrong? I mean, obviously we know there were reports that he was like sweaty at one point. He was cleaning things up. He was, when he was asked about someone at Ryan McCann's house said to him, "Oh, that smells like someone just died." He gave like a stern look. Yes, but at the same time, how does someone who does this act as if nothing's wrong? He played pool with Ryan McCann at a bar. So explain this to me.
Well, for lack of a better way to explain it, the prosecution is just going to argue that he's a deranged, sick individual that was able to carry on a normal life after he took four innocent people's lives in a really horrific manner. So I guess some people are able to commit such an atrocious act and carry on with their normal lives. I'm sure that doesn't mean that if he did do this, that he wasn't remorseful in some way, but people try to cover up their tracks, and by having this normal life and ordering pizza to the homes, he was trying to show that he was innocent.
Let me ask you this. I like playing some scenarios here, so bear with me for a second. If the defense tries to say he didn't know what happened to these four individuals, he just showed up at the house, they weren't there, he decided to take care of his son who was alone in the house, maybe he felt like he was just going to hang out in the house, okay? He made 120 phone calls to Megan from the night of August 27th to the afternoon of August 28th, and then never tried calling her again. So even if he thought that they were away in West Virginia, which is what he claimed, he never called her again after that date?
All right, well, hopefully the prosecution is watching you, because that's something that they should absolutely highlight in their closing. That's very peculiar. Why didn't he continue to call her? I mean, he did not commit the perfect murder. He certainly neglected to continue calling, which is something he should have done, especially since he had the child. So I'm sure that the mother, had she been alive, would have wanted updates on the child. So none of this really makes any sense.
Yeah. Do you think, let's talk about that phone call that you mentioned, the phone call that Megan Brown made the morning of August 28th, okay? So based upon the timeline put forth by the prosecution, Matos killed her later that day. So the morning of, she made a phone call to the police saying that Mr. Matos threatened her with a knife, okay? You don't usually have a victim in this case in the same proximity on the same day in question talking about her fear of the defendant here. How much does that hurt the defendant?
I mean, if I was the defense, I would have argued as hard as I could have, defense attorney, to keep that out. I think that is so prejudicial because, of course, somebody that's threatening to kill the person earlier in the morning, it's very easy for the prosecution to say he made good on his threats. So it's very damaging to the defense that came in, that the jury is going to be able to hear that and hear her fear.
And the defense, all they did was try to keep out the portion of the phone call where she talked about his ethnicity. They felt that that was going to be unfair for the jury to hear. But like you said, they didn't keep that phone call out. And there's going to be testimony talking, I think, from people that worked and were, Megan Brown's friend, her best friend, and also people that she worked with, her boss, who said that she felt threatened by Mr. Matos. That evidence is going to come in as well.
She didn't go to work that day because she was scared that he was going to take their son away from her. She was pushed up against the wall, had a knife held to her throat. Those are all really bad indicators of somebody acting in a domestic violence fashion, and the next step is taking her life. And that's what happened here. And the defense really should be trying to keep more things out. They need to be throwing in their alternative theory of the case, or at least trying to poke holes. You know, I don't know that there's any real DNA evidence here. You have some issues. He purchased a shovel. That shovel, I believe, was found near their bodies where they were buried. So that's a huge problem. That shovel was purchased with her mother's debit card. You have a lot of issues, but the defense needs to be making some form of an attempt to defend their client more zealously. And I'm not attacking them. This is a very hard case to defend. Perhaps they have a strategy that's going to come out and we're going to say, aha, now I see what they're doing. It's just, it's very difficult to be in this position where I don't see what their defense is.
Yeah, it's interesting, especially, I mean, he was living in their house, using their supplies, using their cars, using their credit cards, using, you know, he drove their van that would eventually have maggots in it and bloodstains. So it begs the question, what is their theory moving forward?
The maggots and bloodstains are also another particularly huge problem. I mean, how could you be driving around in a car like that if even if you didn't do it, then you're going to do something about that. You're going to call the police. You're going to report them missing. There's so many things that could have been done if his loved ones were missing. And, you know, even if they didn't like each other at the moment, you're still going to call law enforcement, or you're going to do something. He didn't take any steps to try to find them. He stopped calling. None of these things are good for the defense.
The savage nature of this quadruple homicide, we're talking about people that were shot, asphyxiated, hit in the head with what appears to be consistent with a hammer. I mean, Margaret Brown had a bag duct taped around her head. These are really brutal killings. In your experience and studying criminal law, do you say that that this aspect of the crime is of a personal nature? It's more committed by somebody who knows these four individuals than a complete stranger? I mean, I'm sure it's not always the case, but I'm curious.
No, I've seen cases where people do brutal things that don't know the individual, so I think it's really just the particular defendant who commits the crime and how they choose to commit it.
Yeah.
You know, yes, I've seen cases where people know each other and the injuries are especially brutal and especially disturbing, but you also see that in cases where the individuals are unknown to one another. So I think that it's really just the individual person and, for lack of a better word, how deranged they are.
How much is the smell going to come into this case? The smell that everybody, I mean, multiple witnesses were talking about it, that there was this horrific smell coming from the house. I mean, a really foul odor. You heard even pizza delivery guys talking about it. It has to come into play.
It's definitely going to come into play, and that's somewhere the defense could say, okay, well, it doesn't mean he killed her. So I don't understand why the defense isn't doing that. There is this individual, the ex-girlfriend of Nicholas Leonard. I would be trying to pin it on her. You have to try to do something. So probably that's where they're going to go, and maybe they're going to weave that in when they have their own direct case. But you need to offer some explanation and just say, look, you know, just because he didn't call the police doesn't mean he's the one that did it. Just because he was living with this decaying, disgusting smell also does not mean that he was a killer.
Yeah, even in the Jeffrey Willis case, which is what we covered, I mean, that was a lot of evidence against that guy. The defense said, don't make your decision until you hear all the evidence in its entirety. And I said, you know what? That's fair. That's fair. I won't make a rash judgment. And all we really had was the timeline now of the prosecution's argument. And based upon the prosecution's argument, it sounds pretty strong. But that's why you have a defense coming forward and saying, okay, we hear their theory. Let's move on with ours. It's not so fast. But all we've been hearing is the prosecution. It seems pretty strong. I am curious, the idea of, you know, this other person coming forward. They said, the defense said, we will elect to reserve our opening argument if, and this was the key word, if we choose to put on our case. Are they weighing to see how strong the prosecution makes their argument? Are they prepared with their own case and try to do a mini trial against this other woman?
Look, the prosecution's case is, at this point, when you're trying a homicide, let alone one where 4 people are dead, you know what's going to come out. There are always surprises at trial. It's very difficult to be the prosecution and the defense because things change at trial. However, due to the rules of evidence, due to the rules of discovery, you have most of the information. There's definitely things change, and that's very hard to deal with, but you know what the prosecution is going to argue. So I don't understand taking the position, oh, maybe we're going to put on a case. You have to know. I mean, the prosecution here is very damaging things. The 911 call itself is extremely damaging. So I would hope that they're going to put on some kind of case.
The judge in this case, I have to say, I'm a big fan of. Okay, I think she's fantastic. She's really been laying down the law. There was an interesting moment in the beginning of this trial where there were some photos of the crime scene. There was maggots. I don't believe there was a ton of blood, but she said that the defense tried to keep it out, said that it was going to be unfairly prejudicial. She said, no, I've seen crime scene photos before. It's just a crime scene photo. I don't think this is going to influence the jury one way or another. I'm not even going to give a limiting instruction to them, some sort of warning before they see this. Is that common? Do you usually see a judge with that saying, it's fine, that photo's okay?
Well, I think that it's an individual decision. This judge decided, I'm not going to give a limiting instruction. Every judge is different. They're going to try the case according to the law, but they're also going to have their own personal opinions, and that comes into play, which just highlights the fact that you could have a completely different result if you're in front of a different judge. So, you know, a lot of times the judge that you have does come into play because there are a lot of rulings that the judge has to make. So as a defense attorney, you're hopeful for a judge that's fair. So I haven't been paying as careful attention as to this as I should be because I've been working on my cases, but it really highlights the fact that a judge plays beyond a critical role, because you could have a great case and have a great argument, but if the judge rules against things coming in that really should come in, it significantly changes the roadmap.
Deborah, we know that this common sentence, what you say may be used against you in a court of law, right? We know that statement. The reason I'm bringing this up is because Mr. Matos elected to have an interview conducted by the Tampa Bay Times while he was in jail, where he said the last time I was at the house was August 28th. I didn't have anything to do with this, trying to point the finger at someone else. I don't know why, if he was represented, his attorneys let him do it, or if he wasn't represented, why he did it. How damaging, because we know that interview's coming in, how damaging is it when your client makes a statement to a media affiliate before a trial?
Well, it's not something I would let my client do, so you know, I would really protest against it, but there are sometimes clients you can't control. So everybody has a mind of their own. You could tell your client 1,000 times, don't do it. But some people believe that speaking out and seeking media to come in and interview is going to help you. At least if you're going to do that, then don't say, I wasn't at the home for, you know, X number of days, when there are a million witnesses that are going to be paraded into court to say, I went to a bar with him, he ordered a pizza and I delivered the pizza and it smelled, I bought a dog from him. So it really makes no sense that he said that, but people aren't usually that intelligent. And you know, I always counsel my clients against giving a statement. Sometimes it can be helpful. I have a case right now where my client, I truly believe, is innocent. I also think the prosecutor believes he's innocent, and he gave a statement, and now the prosecutor is investigating that statement, and what he said is really adding up, and I think that the charges are going to be dismissed against him. So in maybe 1% of the cases, or max 5%, giving a statement can be helpful, but generally I fully advise my clients against giving statements.
Because even little things can be construed by lawyers. We know, we do it. We construe it in certain ways to mean one thing when maybe they didn't intend it to say the
Absolutely, and you know, I mean, nowadays you have these video statements where I think that the police give a whole spiel to the client before that's like, you better admit to it. If you say what you did, then we're going to charge you with a lesser crime. So I fully believe that that happens, where it's this pre-party, as I call it, and then the video camera comes out and the defendant admits to it. That's just not good. It never helps your client. I don't, you know, even though you can make the argument to the prosecutor, look, my client was respectful, he admitted to doing what he did, so you should be lenient, but it generally just doesn't help.
Well, look what happened in the Luis Toledo case. He gave a confession in that case, said, I killed my wife, said it was an accident, but then the defense is on defensive, trying to explain that away. So again, it's so important. I mean, we see it in movies all the time. As soon as something happens, they go lawyer, lawyer, lawyer. As soon as they're in police custody, because they don't want to say anything.
But everybody, again, that goes back to people thinking that they can talk their way out of it, and they just usually cannot. But sometimes I've had cases where this was going back, a bunch of years, where the police will write out this statement and then force the client to sign it. And even just speaking with the client, representing them, you realize that there's no possible way that your client could ever say that. Either it's way too articulate of a statement or it's not how they speak. So back in the day, it was easier to argue that to the jury, whereas now everything is videotaped. So it's hard to really attack a video statement other than saying, look, there was this pre-party, which often there is.
Right. I like that pre-party.
Yeah.
Motive. Motive's not an element of a crime, but it does help tell the story. We saw it in the Luis Toledo case. The prosecution said that Mr. Toledo killed his wife because she was having an affair, and he killed the children because they were witnesses. Here, in this case, we have a kind of a general understanding that they weren't in the best kind of relationship. Obviously, she was seeing someone else. I think their relationship kind of dissolved at that point, but he said that he was going to be working, get a job, take care, provide some sort of support, but he really wasn't doing that. But we're not entirely clear on why this happened. Why would he kill this young woman? Why would he kill her parents? And why would he kill her boyfriend? Since that hasn't been articulated, does that hurt the prosecution?
I think that we're seeing this emerging trend in America of these gruesome murders, and I really don't understand what's going on. I mean, it just happened in Texas where all of these innocent people, families, are lost, and the same thing happened here. I don't understand why anyone thinks it's okay to do this. If you want to take a life, then take it. I'm certainly not advocating suicide. Take your own life. If you have this much rage, why are you going to kill the mother of your child, her parents, and her new paramour? It just really, it doesn't make any sense. So I don't think that that's necessarily going to hurt the prosecution, because this guy, they're just going to say is a really despicable human being.
Look at Las Vegas.
Yeah.
Las Vegas, still trying to understand what happened there. This is a possible death penalty case, okay? So if he is convicted, Mr. Matos, it's possible he does face the death penalty. Now, I have to tell you, part of me was surprised in the Luis Toledo case when you had a jury convict this guy of first-degree murder and the killing of those two children, and they 10 voted in favor of the death penalty, 2 voted against it. Now, in Florida, there was a new law. They used to have a majority ruling. So you only needed a majority of jurors to find that he was death penalty eligible, which means for Mr. Toledo, he would have been eligible for the death penalty. Here you need a unanimous jury verdict. How hard is it? Apparently it's very hard, but I'm curious from your perspective to get a jury to vote in favor of death penalty.
In New York State, we don't have the death penalty. In federal court, we do have the death penalty. So I haven't handled a death penalty matter in federal court. So my state clients also are not facing the death penalty. But I remember with the Boston Marathon bombing, when he did get the death penalty, look, sometimes I really believe that it would be worse for someone to rot in jail than to have the easy way out, which is to not have to be in a cell every day for the rest of their life. So, perhaps that's why the jury, even though they're not going to necessarily articulate that, maybe that's why in Toledo, they decided not to give the death penalty to those 2 holdout jurors. I definitely agree with Florida's new ruling that it must be unanimous. There were delays in cases while they were trying to sort out what the rules should actually be, because you're taking someone's life. But there also, I think that, as we talked about here while we were covering that trial, the fact is they didn't have the bodies. So that was maybe a really, really big issue, and we don't really know how the children died. You had their things discarded in a garbage dump. That was really upsetting. The jurors got to see those items, but you didn't know how they died.
Yeah.
Here, we know the steps, that he went through to get rid of these people and kill them. So I think having those details might lead to a higher chance of him having the death penalty imposed.
Interesting. This is an interesting question I'm about to present to you, because I don't have more information about it, but I am curious where we go through with this. We know that Adam Matos had a 4-year-old son with Megan Brown. We know that this 4-year-old son, who goes by the name Tristan, was in that house, okay? We know that he suffers from autism. Do you imagine that the police or investigators questioned Tristan about what he knew, what he saw, and how reliable would that be? He's a young boy. He does suffer from autism. How reliable would that be going into a courtroom?
Well, usually, generally, you're not going to hear testimony from a 4-year-old. It's just not going to be reliable. But you do see in a lot of cases where a child could be the victim of a crime and they are interviewed by law enforcement, and law enforcement has their techniques. But at the same time, I remember having this conversation with my best friend. She said her brother was once interviewed by law enforcement and gave a false story, even though he's a great guy and very trustworthy. But kids sometimes lie. So, because everybody else was doing it, he went along with that. Or maybe, things got mixed up in this young boy's head, and just this experience itself is so traumatic that perhaps he's suffering from something where he can't even recall the details. I'm sure law enforcement probably did try to speak with him and see what they could elicit, but having this 4-year-old testify, especially if there are some limitations that he has, he's not going to be able to.
So it's possible we might see testimony from an investigator, perhaps even a doctor testifying, maybe did a review of this young boy after the events of this case, and just hearing what he told him. Is there any kind of evidentiary issues?
Yeah, that could be complete hearsay. So there would have to be, maybe a hearsay exception. There probably could be one. This would, again, be a balancing test that this judge would then make the determination, but I don't know that we're going to hear any of that testimony, because 4 years old is very young. There's a big difference between a 4-year-old and even an 8-year-old.
Of course.
So I don't think that's going to come in here, but just anything having to deal with a child having such a terrible, terrible experience is also very traumatic for the jurors to sit through and listen to. And I would argue as a defense that that's going to completely prejudice the jury and try to keep it out.
Interesting. We saw the testimony yesterday of, it's very sad, of Gregory Aaron Brown. Now, he is the son of these two parents that were killed, the brother of Megan. Really tough for him to put in the stand, because you can see what he had to go through. I thought it was interesting. I was expecting testimony about what did you think of Mr. Matos, what was their relationship, more personal details, and really what the crux of his testimony was about identifying the weapons that were found that seemed to belong to Gregory Brown, the father in this case. What I thought was interesting, he wasn't really grilled on what he viewed of their relationship. And I'm curious, is it, a circumstance of maybe he just didn't know what the relationship was like? Or is there something else that I'm missing here about really putting him on the stand for that purpose?
You can't always get into somebody's character, can't always be on attack. There are different rules. I'm not familiar with what the rules of this state are, so perhaps there was a reason why the prosecution isn't allowed to get into that. There could be a limiting ruling that the judge gave that we're not aware of that said you can only elicit testimony pertaining to X, Y, and Z. So that's a possibility. Or the prosecution has gone there because of other witnesses that are able to testify to that, and they just felt that they needed to get out of this witness what they got out of him.
Interesting. Do you have any final thoughts before we turn to, we're hopefully going to turn to our live feed soon, but we might turn to a clip beforehand.
Well, I'm just really curious what the defense is going to do. I would like to get to that portion of this trial to see how they're going to try to give their client a chance.
Yeah.
And again, I'm not attacking them.
Yeah.
This is a very difficult case to defend. I'm sure they're going to do something. It's just, I'm waiting to see what that is.
Yeah, well, we'll have to wait and see. Deborah Blum, thank you so much for talking about this case as we do wait for our live feed, so thank you again.